welcome to the Ask the Expert series. So I'm Kimmy Ortega, and today I'm super excited to introduce you guys to Mr. Matt Davidson with Davidson Law Group. So they are a great estate planning firm that I have known for years, and oftentimes I get tons of questions from clients and just from my sphere about estate planning and what should I do, what shouldn't I do, what's the best plan. Ultimately, it's super custom to every single person, so there's not a one-size-fits-all for everyone. But I thought it'd be great just to ask some burning questions that I get often and see if we can help answer some things for you guys. So, really, estate plans are not just for the older population. A lot of people hear that phrase and they think, oh, that's for my grandma or my parents. And it really isn't. So you can have an estate plan at any age. Once you really start owning assets, as I learned from the experts here, that it really is important to have it written out, because at the end of the day, if you don't have a plan in writing, there are powers above or powers that be that will make that decision for you, and oftentimes it's not in line with what you would want. So they are my personal estate planning attorneys, and it was a super eye-opening session when I did that with them several years ago. Gosh, I feel like it's been probably 7 or 8 years. I don't remember.
Yeah.
It's been a long time, but it was just so many different scenarios that I didn't think of. Things that, like, what about this? What if this happened? What about if you did this or that person did this? And it's just like, man, I never even would have thought about what I would want in those. So it's really important to dive in and make sure that your wishes and things that you want are known. All right, so we're going to start with just some basic foundational knowledge, because there is some terminology that we don't all use every day. So I think it is important to define that. So let's go back to some basics here. So first question is, what exactly is estate planning in simple layman's terms?
Yeah, for sure. And thanks for having me.
Yeah.
I'm glad to be here. So people hear estate planning and they might hear a couple of things. They hear real estate. Maybe they hear it like lifestyles of the rich and famous, I have an estate,
Yeah.
But that's really not what it is at the end of the day. Yeah, assets and talking about what happens with assets is part of it, but really your estate planning is what happens with your assets, your children, what happens with your children, who's going to be the guardian, who's going to handle your financial affairs if you're unable to do so. Who's going to handle your medical affairs if you're unable to do so? What's going to happen with your remains? Who's going to handle your remains? What do you want? Do you want cremation or do you want burial? So yeah, a lot of it does have to do with protecting assets, tax planning, liability planning. But really, it's a broader spectrum than that, and that's why the question's not whether you have an estate, because everybody has an estate, right? Everybody has medical affairs. Everybody has to have something happen with their remains. If you own a home, at the very least, you got to decide what's going to happen to it. The question's not whether you have an estate. The question is who's going to create your estate plan. And as you alluded to it, we want to empower people to make their own estate plan rather than have the state or the courts or a judge make their estate plan for them.
Yeah, no, that is spot on. So a question that I feel like I get all the time is, what is the difference between a will and a trust? And a lot of times people, I feel like they make a will and they think they're done, and that's it. But it doesn't always encompass everything, may not always be the right decision for everybody. So what are the big differences between a will and a trust?
Yeah, so when it comes to what's going to happen with your assets when you pass, everybody's on a spectrum. If you have nothing, then the laws of the state of Texas will control what happens with your assets. The next step on the spectrum would be having a will. If you have a will, you at least are telling the world what you want to happen with your assets, but that will still has to be approved by a judge and go through the court probate process. And then the other side of the spectrum from having nothing would be having a trust of some sort. Most people, it's a revocable living trust. And the biggest difference would be avoiding the courts, right? If you have a trust and you have all your assets in it, then you avoid the courts. If you have nothing, or if you just have a will, then somebody's going to have to go to court for you. But there's all kinds of other customizable bells and whistles that can be put into a trust. Minor children is a big one. If you want immediacy, for your guardians to be able to have the assets to be able to continue raising your children, the trust is much more immediate. The will has to go through the process before anybody's going to have access to those assets. Another big one is privacy. Anytime you probate a will, all of the information about the assets and the children, it's all out there on public record. Anybody can go search the probate records. They're all public. Whereas a trust passes assets in a private manner where it's never public record, who's inheriting, how much they're inheriting, where they live, any of those types of things. And then, some of the other bells and whistles that would be in there, setting up a trust that creates trusts for children or for siblings that can help protect them from divorces, bankruptcies, lawsuits. And also, a lot of people are concerned about if I die and my spouse remarries, what's going to happen to my assets? It's going to end up going down a completely different line from my family. And so in our trust, we put a lot of remarriage protections in there as well to make sure that, especially those with children, make sure that assets will go to the children after the second spouse passes, even if the surviving spouse remarries. So big ones are avoiding the courts altogether, immediacy, and privacy. And then all of those other bells and whistles that I talked about are things that are typically put into a trust and not into a will. And what I typically walk my clients through is a compare and contrast, pros and cons of each. I mean, with a trust, you have to do more work up front because you have to move assets into it.
It was a lot of work.
Yes, it is a lot of work. But it's worth it. But with a will, you just set it and forget it. Anything that I have goes here. But obviously, you see the pros of a trust as I've already laid out. So putting that little bit of extra work in. But I walk my clients through that analysis and let them decide which one fits their goals and desires and objectives and their family dynamics the best.
Yeah. No, I mean, that's so much. I mean, a lot of people don't realize the privacy part of what you said. Like, I mean, I know I wouldn't want all my business, out there. I mean, not everybody knows how to search it, of course, but
the fountain of the bots, that can sweep through. Anytime we file a probate, the clients almost immediately call and say, how come I got all this mail from all these people wanting to buy my house or do this or do that? Not everybody knows how to search it, but there are a lot of softwares that they sweep in and get all the information. So that's pretty crazy.
Yeah. And I think too, the remarriage, and I feel like, one of the questions that I've gotten and that I had as well was, there's so many blended families right now. And there's, you want to make sure that if something were to happen so I'm, a blended family. And so if something were to happen to my husband and I, we want to make sure that my stepdaughters are the ones who solely get it. And that there's the ex, is not part of controlling that money or has access to that money, because we want to make sure it is strictly for her benefit. And so that was so important for us to go through that and make sure that our wishes are protected and that there's layers in place to make sure that what we want is exactly what will happen and legalities are there. So that was really, really important. So blended families for sure need an estate plan.
Absolutely. 100%. And with blended families, there are even some features of like, if both spouses bring children into a marriage, what's going to stop the surviving spouse from leaving everything to just their biological children? I know in your scenario that would never happen, but there's some that are newer blended families. Maybe they aren't as close to their stepkids, and we want to definitely protect from all of those things that you're talking about.
Exactly. Yeah. Okay. So I'm looking at my notes here to make sure I have all the questions that everybody has asked. So let's see. We talked about that one. So this is a good one. So some of the questions is, can I add my adult child to the title of my house in case something happens to me so that they get the house? And before you answer, I definitely get this question a lot because people often think that's the best way to ensure their wishes, but what they don't realize is then they're just part owner and they're still the person who I'm talking to, my client, their share still doesn't automatically go. So can you touch on that a little bit?
Yeah, absolutely. So can you? Yes. Should you? No. Not only does it not accomplish what you think it's going to accomplish, because most of the time deeds at title are not drafted in such a way that it would automatically pass to the other owner. That's typically not the case. But even worse than that, and this you could take this same concept, and there are exceptions to this rule, but you can take the same concept and apply it to, should I put my child on my bank account? Typically, I would say no as well. There are some exceptions to that. But the biggest thing that I see is you're now subjecting your assets to the lifestyle follies potentially of your children, right? What if they go through a divorce and then now the house is in the middle of that?
Oh, yeah.
What if they get in a car accident that's their fault and get sued? Now it's part of that lawsuit. And so that's a big one that I want to avoid. And especially when there are such easy alternatives to putting your child on your house. At the very least, you could do a transfer on death deed or a ladybird deed.
I've heard that. And ladybird deed, that's specific to Texas, right?
There's a few other states,
okay.
but not all states have it. But basically what those deeds would do is while you're alive, it's your house. You're not subject to the woes of your child's life. And then also, immediately upon death, the house would then go to the child.
And it wouldn't go through the courts?
It would not go through the courts. Now, another big one is, don't want to get too deep into tax stuff, but to give you a general concept, when a person passes away, if the child were to then sell the house, to make a long story short, their capital gains liability would be greatly reduced, if not eliminated altogether. But if half the home was already owned by the child, then you don't get that same capital gains protection. If you want to look it up on your own, it's called the step up in basis. But we don't want to get logged down on that. But that's another big reason not to. And a transfer on death deed or a ladybird deed does get the step up and the capital gains protection for the child as well.
Yeah, so that would be definitely a more effective way to accomplish the goal.
Yeah, for sure. And
protections.
If you're going to go all the way, then go with the trust to do it.
Right.
It would be just as seamless, but at the very least, you could go with one of those types of deeds.
Yeah, no, I love that. So, okay. So another question that I got, I think we kind of already touched on it, but just see if you have any other thoughts on it. So, let's see. Okay, so does an ex-wife have any rights to a property if they were not on, or like, let's say if they were not on, or if they owned or lived in, if one, let's see, hold on, the question is actually worded a little bit weird. Basically saying like, does the ex-wife have any rights to a property if they were not an owner of it? But then the owner passes, but they share a minor child. So let's say that I'm divorced and, I'm primary caretaker of my kiddo. And then like I pass, does it go to my ex-spouse? I guess the question is, if you don't have a plan in place, what would be the automatic default?
Yeah. So if you don't have a plan in place, it's going to go to your heirs. So you don't have to worry about it necessarily going to the ex-spouse. But if you don't have a plan in place, and let's say your children are your heirs,
and they're minors,
then presumably the ex-spouse is going to control everything, even if they don't own the asset itself. Technically, the children would own the asset, but the ex-spouse would control it. So many times when I do have divorce situations, a plan is very important because you could actually put a different person to be in charge of the assets if you passed away, even though biological spouse or mom or dad is probably going to get the children and be their natural guardian. You can make it where they don't get to control the assets that the children just inherited. That's why it would be so important to have a plan. So I know it's a nuanced answer, but in a nutshell, no, ex-spouse wouldn't get the assets, but they could potentially control the assets for the children. So you'd want to put a plan in place to make sure that the person you wanted, your brother, your mom, your dad, controls the assets that you left behind to your children and not the ex-spouse.
Yeah, that makes sense. Okay, so it's a fun question.
Okay.
Can my dogs have a trust fund?
Yes. So I love doing pet trusts. So oftentimes we have our clients' revocable living trusts create a pet trust for animals. I even had a ferret one time. So you set aside a certain sum of money, $10,000, $20,000, to be held in trust that can only be used for that animal. And then you put a caretaker in there, and the caretaker gets the animal, and then you put a trustee in charge of the money, and the money can only be used for the pet. Veterinary care, boarding, all the maintenance for the pet. So yes, absolutely, you can do a dog or a pet trust, and we actually do them more than you think.
That's so interesting. I mean, it makes sense. I'm a dog person, so
Yeah,
I get it.
yeah.
I get it. Okay, how often should someone review or update their estate plan? Or what might prompt the need for some changes?
So, two types of changes that could occur. Personal changes, right? Someone passes away that you have in your plan. So you have a falling out with someone who you have in your plan. Just a new stage of life, and you need to change something about your plan. New child. You want to add a pet trust. The personal changes, but there's also legal changes. And oftentimes, Congress or the Texas legislature will make legal changes that will directly affect your trust and the language in your trust. So those types of changes could pop up at any time. So at our firm, we approach it two different ways. One way is that the client comes to us ever so often on their own volition and says, hey, we had these personal changes, and then we also want to know what legal changes have occurred since we last saw you. And then we'll tell them, and then we'll make the changes and move forward. And then the other way is we have what we call the client care program, where clients can pay an annual fee to have as many changes as they want. They could come see us 100 times throughout the annual period and make changes. But also, the kicker is that a lot of people, you mentioned it's been a long time since we've seen you guys.
I have some updates.
Right, and so, and that's very normal that, people will kind of let them add up before they come back and see us. So the kicker on the client care program is that we reach out at least once a year and say, hey, you need to come in and let's talk. And inevitably they will say, oh, good, we were just waiting, to come see you. We have all these changes that we want to make. And then I say, okay, great, because I had changes too. Congress did this, or the Texas legislature did this. And so either of those ways work, but the client care program guarantees that at least once a year your trust is going to get updated. And that's with trusts and wills, but also powers of attorney. They can go what's called stale, which means that if they get too old, then there's a chance that institutions might not accept them. And this is the cover your butt thing for the institutions, because if it's too old and somebody abuses the power that was given to them under a power of attorney, then the person could come back and sue and say, hey, you should have been suspicious of this because this is really old. How did you know that this person was still in favor with me? So a lot of banks that I've talked to and a lot of financial advisors that I've talked to, I think Edward Jones, maybe 5 years, Schwab, maybe 5 years, some are even 3, that the powers of attorney, even if there's no change, need to have
A fresher date.
a new date. And plus, whenever we do trusts, a lot of times if a client wants to go sell their home that's in the trust, the title company will ask for a refresh date on what's called the certificate of trust, which shows, hey, we looked at it again, everything's still accurate, you can rely on these trust documents.
Yeah.
And so the answer is that it's very subjective depending on the institution, but if you want to be 100% safe, then you should check on it annually. At the very least, you should really be looking at it every 3 to 5 years.
That makes sense. Okay, let's see here if there's any other questions. Are there any specific considerations or strategies for estate planning in Texas that our lovely Texas residents should be aware of?
Yeah, I mean, there's some super unique things to Texas. So we are one of several what are called community property states. which means that everything that's earned during a marriage, regardless of who earned it and regardless of how you even title it, is owned 50-50 by the spouse, unless there's a prenup or a postnup that says otherwise. And then your separate property is anything that you can prove you had before marriage, anything you inherited, or anything that was gifted to you. But another kicker in Texas is that the income that's earned off of community property or off of separate property is community property. So this means that there are certain things that have to be built in to a Texas trust to adhere to the community property laws. Plus, in Texas, if you want to own your home in your trust and you want to keep all your exemptions, homestead for some people over 65, some people have veterans exemptions, that has to have certain language in the trust from the Texas tax code and the Texas property code called qualifying trust language. I get hired all the time for people who move in from out of state and they go to put their home in the trust, and then the appraisal district tells them you can't have your exemptions because it's a California trust and doesn't have the right language, and they come see me and we update it. So those two are the big ones, but there are multiple things that are Texas specific. So if you move in from out of state, you really should see an estate planning attorney to get your plan updated.
The prompt, yeah.
Plus, wills and powers of attorney are very different in Texas than other states. Trusts are very portable. You can move them from state to state with just making those updates. But a lot of those other, what we call ancillary documents, like powers of attorney and wills, are very unique to Texas.
Interesting. Okay. So can you share any examples of, besides maybe the pet trust, but any unique or challenging cases that you've worked on in estate planning? Obviously, you can't, disclose any private information, but just any scenarios that maybe someone could relate to.
Yeah, I can think of a couple right off the top of my head. I mean, a big one would be estate tax or death tax planning. We're flying high right now in a time where most Americans are not subject to their estate being taxed whenever they die, because I always put it this way: the estate tax exemption is the amount of money the government says you can die with before they tax it. And right now the number is really high. But only 25 years ago, the number was 600,000. They were going to tax everything over 600,000.
Seems really low.
I know.
And what is it now? It's like 5 million or something, right?
Doubled it now.
Oh, okay.
So it's up into the 13s. But the thing is it fluctuates.
Politics.
Politics, exactly. And the Trump era law that put it at the 11 to 13 space is going to expire at the end of 2025. And it's got to switch to something else. And so it can very easily go back to around $1 million. And I would be shocked. And so a big part of our planning is that, and it's not just for the ultra wealthy because of what it could easily go back to in the future. So it's pretty cool. I have a case where when the first spouse died, they had a trust that was like one of our trusts. And what those trusts allow you to do is to set aside, earmark a certain amount of assets that you can still spend, but because you made this earmark within the trust, those assets and their growth would pass to your children outside of your taxable estate. And I had a client who, when the first spouse died, the number was 600,000. So the wife earmarked around $600,000 worth of assets. Those assets happened to be minerals, and at that time, that's all they were worth. Fast forward to when the wife died, we got those minerals valued, and they were valued at multiple millions.
Wow.
Over $15 million. So that amount of assets would have been taxable at 40% over a certain amount. Millions in tax.
Wow.
Were saved because of a certain type of trust that we do.
Yeah.
Another big one, which is kind of, I'll tell two that are warnings about not having a plan at all. I see it all the time where we have a blended family, and everybody always assumes that with no plan that everything goes to the spouse. But that's not true. In Texas, if you're a blended family and you have children from outside of your current marriage, your half of everything goes to your children. not to your spouse. So I've seen so many cases where the spouse is now jointly owning assets with their stepchildren because there was no plan. I even had one where the wife died and didn't have a plan, and the husband did not even know that his wife had adopted a child 30 years before, found the paperwork, and then I had to be the bearer of bad news that now that son that you didn't even know existed and didn't even have a relationship with his mom is getting half of all your assets. And so those are very difficult situations. But then also, I had an interesting one where there was a same-sex couple, and one of the part of the couple had adopted a child, and then was together with their partner, and they never got married. And the one that did not adopt the child passed away, but the child really needed to get the assets from that one. And I mean, the child, called her mom and everything. And so we had to work really hard within the courts to make sure that the assets could be shifted over to that child and not to the partner. And that's another consequence of not having a plan. And that was a very strange one.
Which then I'm sure racked up all kinds of legal fees and things, which, I mean, obviously, that's how you guys stay in business, but that's not ideally how you want to probably earn it.
And obviously, if there's a mess, we make more money. But that's what's interesting about what we do is that we get the privilege of handling estates on the front end and then also cleaning up messes on the back end. And if we handle it right on the front end, I could care less whether I make money on the back end. My job is to make it clean on the front end.
Yeah.
And so I could tell you a million stories about consequences of not having a plan at all. The tax one is big. The remarriage one is big. So many situations where we've saved the children to get their inheritance. I could tell you a million stories, but those are some of the ones that come to top of mind.
Yeah, no, I think that's great. Well, I think this has been extremely helpful, and I feel like lots of information and lots of guidance for anyone who is watching. So if you weren't sure, you should be sure now that you need an estate plan. So for anyone who may be interested in reaching out, if they would like to contact you, we are in Fort Worth, Texas. Do you guys serve Texas only?
We serve Texas only, but we serve pretty much anywhere in Texas. We have clients in Houston, Austin, San Antonio, West Texas. We travel all over. Our offices, though, are in Fort Worth, the border of Keller and South Lake, Flower Mound, Allen, Tyler, and then our newest office right in the heart of Dallas.
Okay, perfect. So mainly DFW, plus East Texas. Tyler's not really part of the
North Texas mostly.
Yeah.
We'll travel.
Yeah. Gotcha. And then, so how would someone reach out? Go to your website or?
Yeah. So, what we do at the heart of it is we help protect people's legacy. So our website is yourtexaslegacy.com. Go to the website. You could find all the phone numbers, all the addresses, email address. You can find out more information about us, blogs. Our most visited blog is What's Right for Me, a Will or a Trust. If you want to see more about what I talked about at the beginning. So yeah, yourtexaslegacy.com. Davidson Law Group is the name of our firm.
Perfect. Well, we really, really appreciate it. And stay tuned for the next Ask the Expert series.